What's up, guys? Welcome to Lawsplaining the Interwebs. I am your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. And I am here on Easter Sunday, the day that Jesus Christ conquers death with perhaps the worst attempted resurrection in the history of the world, Kevin LanDUI attempting to rehabilitate the shattered, sad remnants of his legal reputation, whatever they may be. So, if you're not aware of what has happened, Kevin frickin' LanDUI has decided to file documents tonight in anticipation of tomorrow's hearing on the 2 sanctions motions against him, and I guess in defense of his own flaccid, pathetic sanctions motion. I have read 1 page of this document and immediately shot into rage. My giggle and laughter is merely an attempt to staunch the welled up aggression. So let's see what we have. So a couple things to cover real quick. Keck says, Happy Easter, Nick. Jesus forgives, but Lady Rackets does not. Go buy something nice for her. Oh, thanks, buddy. I definitely will. As always, if you haven't watched one of these live streams in a while, we've got a new format, and I'm only mentioning this because I got a comment about it. All of the documents are front-loaded, so no matter how long this live stream goes, the documents come out pretty quickly, and then we have some extra time afterwards that we go through. So if you're worried about I don't know how long the stream is going to be tonight. Hopefully not eternal. We have one pretty short document to go through, but however long it is, the actual information on the documents will be in the first portion of it once this housekeeping section is done. So don't be discouraged if it's a longer stream. Check out the first part and then stop watching whenever you feel like stopping. Also, you can check out the audio versions that'll come out on Google and iTunes probably sometime early tomorrow morning. Whoa, I remember that game says patreon.com/Asterios. Definitely check out Asterios' Patreon and help fund the comedy that we've been witnessing. Niels Abel says, what exactly is a sanctions? A sanctions can be a lot of different things. It depends on what the court chooses. It can be anything from a dismissal of the claim on up to actual monetary penalties for either party or the party's counsel or both, and it can be requiring either the party or the party's counsel to pay the other party's attorney's fees. And it can go beyond that as well. So I have not properly hydrated, so I do have this Sprecher Red Apple. Good stuff. This is non-alcoholic, and I will be moving to Balmore 15 in just a second because I think we're going to need it. And as my channel is not sponsored by any liquor company, I encourage you to drink as irresponsibly as I do, which is at home at a very moderate pace when you're not going to drive afterwards. So that is definitely what we need to do. And yeah, let's see what we've got, okay? Let's see what we got. I'm just gonna jump into the documents. Oh, the housekeeping part that I'm forgetting. Once I get into the documents, I'm going to basically ignore the chat, other than super chats. Of course, I will always address right away or as soon as I'm able. But if you have questions and do not want to super chat, they will get answered at the end of the stream if you save them up and ask them. So, please bring those questions. I don't require anyone to pay to get their question answered. But if you do super chat, of course, I will address it quickly, and I really appreciate that. Thank you. You guys are the sponsors of the show. So there we go. Sprecher is GOAT. Puma Cola above all. I haven't tried the Puma Cola. I'll get some. for humor, patreon.com/LanDUI. Fund the Uber. Fund the Uber for LanDUI so he can make it to court. Otherwise, the comedy might be less than if he doesn't. All right, guys. Let's hit these documents. Here we go. Plaintiff's reply memorandum of law in further support of motion for sanctions, costs, and attorney's fees. There's an apostrophe. There should be an apostrophe. Oh, okay. So I'm going to break the rule one time just because Andrew Gluck wants me to say what the name of the Ardbeg is. The Ardbeg Scott. It's my $1,000 Patreon goal is to buy a 4.5 liter bottle, or not goal, but I guess what's going to happen is buying the 4.5 liter bottle of Ardbeg Urgidile. I don't know how to pronounce that. I'm not Scottish. You see this? This is a Polish nose. So I have no idea. But yes, I will buy a large bottle. If it works out, I will bring the bottle to a road rage or something and share it with you guys. So it will not just be consumed by me, although consuming 4.5 liters of liquor does sound like a hilarious evening. Baron Nathan Dean says, is it bad if he totally ignores the criminal impersonation bit and pretends it was never mentioned? Yeah. LanDUI seems to have a penchant for ignoring arguments, though. I would never ignore an argument. Buff G Bob, I was raised Catholic. So, and as for being Protestant now, I mean, I don't know that I'm declared for any team at this point. So however that works out, I don't even know what denomination I am. What even is a denomination? So, all right. But yeah, getting back to the question, ignoring the criminal impersonation bit is bad. Absolutely. Except I will give a mild pass in this case because the criminal charges are not really at issue here. The fact of what Maddox did is irrespective of the criminal charges. Okay. So, and I have been harsh on Maddox, but if you watch the last stream, I have this lingering suspicion that maybe, and I have nothing to base this on other than just a nasty gut feeling and a pity for someone who might not be very good at life. It kind of seems like maybe LanDUI advised him to do some of these steps. And I think LanDUI was certainly aware of the Heather misrepresentation because he put the quotes around Heather. And that really, it's disturbed me from the onset. It's why I initially doubted that Heather was even a person that existed. But as it turns out, as we got more information, we of course found out that Heather was Maddox. But I think maybe that there's some misrepresentation going on. And guys, people hire attorneys supposedly to listen to them. And so if Maddox hired this guy and he gave him that bad advice, like that's a really awful thing. And if that's the case, we should actually feel a little bit bad for Maddox. A little bit bad. There are attorneys out there who do unethical things and advise people to do unethical acts. And it's really a shame. They make the rest of us look bad. And that is a possibility. And the problem is, you know, you're purportedly paying a fortune for an expert. And if you're not listening to that expert, what are you doing? So I'm trying to temper that a little bit and wonder if Maddox is being had, but it's hard to say because he also did make the rapeless video, and that's just shameful. So, one final thing that I forgot to mention or emphasize enough, it is Easter Sunday. I hope you all had a wonderful day and got to spend it with family, whether you're Christian or Jewish. And if you're Jewish, think about Easter. I mean, kind of rude. Just kidding. It's a joke. Whether you're Christian, whether you're Jewish, whether you're whatever, it doesn't matter. I hope you got to enjoy the day and spend time and spend time with family and friends and people who are important to you, because that's what holidays are really about, is spending time and fellowship with the people we like. So, that said, on to horrifically mocking a disaster of a document. Okay. So, further support a motion for sanctions, costs, and attorney's fees in an opposition of defendant Coke in Noses cross motion for sanctions. Here we go. I don't even care about your stupid table of contents, you stupid. Plaintiffs respectfully submit this reply memorandum of law in further support of their motion for sanctions, costs, and attorney's fees and in opposition of defendant Coke in Noses cross motion for sanctions. Axiom says, took your advice on Bible for Normal People. Great podcast. Well done, sir. Thanks, buddy. I think so too. It's a good one. And those guys deserve listeners. Their education's cost probably even more than mine. And so any little bit of support they can get helps, even if it's just a click. Preliminary statement and factual background. Thank you, Justin Werlinger, for the super chat. Plaintiff refers the court to his statements of facts and the letters and affidavit annexed to plaintiff's memorandum of law in support of his motion for sanctions dated and filed on March 14th, 2018, which is incorporated by reference as if stated in full herein. JR says, in your opinion, chances plus minus LanDUI wins the case. I think the whole case, there's him winning this case, I think would have to be reframed as maybe it gets past dismissal and gets settled in some hilariously underwhelming way. Maybe. And I think that would be a massive win, in all honesty, because I think that they deserve $0 in this case and maybe to pay everyone else's attorney's fees. But so anything that they walk away from this lawsuit with is a victory in and of itself. But I think the overwhelming odds are, even if this motion is defeated, I think it's a really, really strong case for every defendant. The worst off defendants are probably Asterios and Dick. Asterios because he's in New York. Dick because he's the nexus of most of the events. However, I don't personally find any of the stuff alleged in the complaint to be actionable, and certainly not in the state of New York. So I think the defendants all come out of this as victors in the sense of we just spent tens of thousands of dollars on legal representation, but we're not having to spend millions of dollars paying a bald Armenian. So I think that's the likely outcome. I hope and think that the motions to dismiss will all be successful. I honestly do. But like I said, I've said multiple times, we're dealing with a human element. We're dealing with a judge who does not know everything that has happened in this case. And whenever you've got a human involved making the ultimate decision, it's tough. And if it goes, if it gets, eventually it'll get to a jury if it keeps going. And then you've got, you can run the same case past 3 different juries and get, plaintiffs, hung jury, and defendants. Like that'll happen. So there's no way to know what's going to happen there. It says, Aria says, it's my birthday, and I'm at a casino bar in Atlantic City with headphones on, watching this and drinking. Can't miss this. Have a drink on me, dude. Thanks, buddy. Enjoy, and happy birthday. Happy birthday. Thanks for watching. Show a friend at the bar and get them wrapped into this, too. Okay. Mr. Greenberger's... This is about where I stopped after this line, because I wanted to uppercut the earth. Mr. Greenberger's conduct in this litigation continues to be appalling and unethical. How is it at all unethical? He made fun of you a little bit in code. That's it. And you deserved it, you dummy. And he should be referred to by the court. He should be... This is why English is important. He should be referred to by the court to the First Department Attorney Grievance Committee. What should he be referred to as? What? How should we refer to him? What grievance do you have? You don't even lay it out. In an attempt to cover for his own unethical and disingenuous conduct, I'm guessing he means the letter. I'm guessing he means the letter. Internet tab. This is a paradox. I don't know what to do. I don't know what to do. Jason Werlinger says, can we start calling LanDUI lawtistic? Maybe, but I think hashtag lawtism is something that someone has applied to me. So, I think it's meant as an insult, but I don't take it that way. Of course, I don't take insults from many people, if anybody. Okay. In an attempt to cover for his own unethical and disingenuous conduct, defendant Coke Innose and his counsel Jordan Greenberger Hero have decided to file a cross motion not only accusing plaintiff of committing felonies, one felony, I think, unless you count all of the times that he lied, but stating that plaintiff has in fact committed felonies and other crimes against Coke Innose. Oh, wait, what? Mr. Coke Innose is the victim of a crime. He is the victim of a crime. It's criminal impersonation in the second degree, which isn't a felony. It's a misdemeanor. Referring to him as an attorney at LOL. Okay. I will. Kevin LanDUI, attorney at LOL. Oh, my goodness. Further, Greenberger requests the court to refer plaintiff to the district attorney's office in addition to striking his complaint for committing a fraud upon the court. Absolutely. And he should. And it's within the court's power to do so. So you can ask for it if there's a good faith grounds, and there is. As indicated in plaintiff's motion, this type of conduct has no place in this case or in any civil case or litigation in this court. It is unethical, no. And frivolous conduct, no. Meant solely to harass, no. And gain an advantage in this case, no. You're one to talk, you scumbag, because you filed 2 motions solely to gain advantage in this case, and now a third. You are one to talk. Oh, you're garbage. Which violates the rules of professional conduct, no. And the rules of this court, no. See Code of Professional Responsibility Disciplinary Rules 7-105A provides that, quote, a lawyer shall not present, participate in presenting, or threaten to present criminal charges solely to obtain an advantage in a civil matter. The criminal charges don't obtain an advantage in the civil matter. Read the comments. Read the comments to the rule, you moron. It is clear from Coke Innose's frantic cross motion that neither he nor his counsel, Mr. Greenberger, have read plaintiff's motion or plaintiff's complaint. They responded to your complaint. They went through several of the invalid arguments. They laid them all out in a document. They quoted it heavily, you flipping idiot. Mr. Greenberger accuses plaintiff of repeatedly and under oath representing the court and to the defendants, quote, that he was not the female Condé Nast reporter, Heather, who sent emails to Mr. Coke Innose's employer, defendant Weber Shandwick, in an attempt to get Mr. Coke Innose fired. Yes, because every time he signs an affidavit saying that the statements made in the complaint are true and correct to the best of his knowledge, when the best of his knowledge was that he was Heather S., then he's lying to the court. That's a fraud. And that's a representation under oath. It's the first line of every affidavit. Upon oath and affirmation, affiant states the following. Mr. Greenberger fails to point to any statement that either plaintiff or his counsel made that Plaintiff Azunian was not the Heather alleged in the complaint who sent emails to defendant Weber Shandwick. Instead, Mr. Greenberger refers plaintiffs in the court to plaintiff's complaint at 64 to 69 in Mr. Greenberger's affirmation. Further, Mr. Greenberger refers to paragraph 73 and 141 of plaintiff's complaint to substantiate his baseless accusations that plaintiff, quote, repeatedly lied under oath and repeatedly denied that he was Heather. Son of a Rex says, LanDUI once again citing the case of rubber versus glue. Trumpio, Maddox is a level 27 Grand Wizard super cuck. Watch out. One of the spells that he casts is to charm you into seducing a beautiful African-American woman. Higgy says, as an FBI agent, everything you post is fantastic. Keep doing you. Sadix will lose, and I will present it to my friends in the prosecutor's office in Manhattan where I live. Whoa! Buddy, if that is true and not an April Fool's, you, sir, are a credit to this nation, and I love you very much. This is, oh my gosh. Oh my gosh. And thank you very much for the super chat, and thanks for being a fan. I really appreciate the feedback. And let me know if there's any interesting FBI style topics you'd like me to discuss. Certainly, because that would be interesting to me as well. Plaintiff Uzunian did not allege that he was Heather in paragraphs 64, 69, 73, or 141 of the complaint. We know he didn't allege that he was Heather. We know that's the problem, not with the entire premise of Greenberger's representation to counsel in the court in his instant cross motion. Because he did not allege that he was Heather, when he was indeed Heather, he committed a fraud. You flipping moron. Bill Kinneran says, I don't get this part. It's saying it did in fact happen just on another page. Isn't that nonsense? Because Plaintiff Azunian alleged that he was Heather at paragraphs 196 to 197 of the complaint. Is that true? I don't think that's even true either. Let me see. I wasn't going to do this, but let's see what we got. 196 and 197 of the complaint. Let's see what we've got. Here we go. Is that the two paragraphs? All right, let's read them. Let's see how honest LanDUI is here. However, just a second. I got to get rid of this thing. Can't see. Weber Shandwick failed to take the requisite action or protect the plaintiff's privacy until such as an investigation was conducted. Gats just got here. What is this new doc on Sunday? Yeah, buddy. Strap in. This is idiocy on a massive level. He's... okay. We'll get to it. Instead, Weber Shandwick effectively condoned defendant Kokonos' conduct and immediately told him about the complaints, whereupon defendant posted about it and promised to exact ruthless revenge against the plaintiffs and retaliate for the complaint, which he did, making everything much worse for plaintiffs. That doesn't say that plaintiff is Heather S., you lying pile of garbage. RZEQDW says, can the judge look at this all and say this is BS and throw it out? Or is there some epic rules lawyering going on here? No. The judge can look at this, say this is absolute trash, you're trash, get out of my court. Absolutely. And he should at this point. He should maybe immediately sanction LanDUI in addition to the requested sanctions, because so far this, and we're on like page 2, guys, and it is disgusting. So then here's paragraph 197. Recently on October 24th, 2017, defendant Kokonos sent a tweet indicating that he had been provided with the said emails by Weber Shandwick, and they had indicated to him that they were sent to Weber Shandwick by plaintiff Azunian posing as a reporter. No, that's you lying about what they said because Asterios figured out who it was. That's not you saying that plaintiff Azunian is Heather S. That's you saying that Weber Shandwick told Asterios that he was Heather S. I hate you. In the sense that I don't actually hate you, because I really try not to hate anybody, but you are a piece of work. Further, plaintiff Orangutan submitted an affidavit in response to Weber Shandwick's motion to dismiss, identifying himself as Heather. Yes, on March 8th. Mr. Greenberger acknowledges this. That's the 5th affidavit he submitted, you idiot. And indicates in his cross motion that plaintiff actually submitted an affidavit in response to Weber Shandwick's motion identifying himself as Heather. Yes, we know. We know. Mr. Greenberger's accusations of plaintiff and his counsel are therefore patently unethical and defamatory. No, they're not. That would be latently unethical and defamatory if it were true. And he is completely wrong and mistaken, which he would have realized if he had simply read counsel for plaintiff's letter or plaintiff's complaint. In his letter, counsel for plaintiff, Mr. LanDUI, attorney at LuL, advised Greenberger and Munoz that their misrepresentations in letters conveniently failed to acknowledge, You don't need a comma there, you dumb moron. That in the subject plaintiff's complaint, Mr. Azunian did in fact identify himself as the person who made the complaints to Weber Shandwick. No, he doesn't. And that defendant Kokonos had even posted about it subsequently. The balls on this guy. The balls on this guy to stand before the court and said, what are you going to believe? What I wrote earlier that you're reading now, or what I tell you now? He has different statements in his own one paragraph apart. As the person who made him the complaints to Weber Shandwick, and that defendant Kokonos had even posted about it subsequently before plaintiff's complaint was even filed, identifying plaintiff George Azunian as the reporter Heather that had contacting Weber Shandwick as follows. We just read these paragraphs. 196 and 197, and it does not indicate that plaintiff George Azunian was identified as Heather. We know he wasn't. All they have to do is produce the email to which he identifies himself as Heather, and you can't cite to the complaint which does not identify you as Heather. Underdog 0. I can't wait for the inevitable Maddox versus LanDUI suit. Man, at this point, if Maddox isn't looking into other counsel, he's, well, I mean, maybe he's just poor. Can even Jesus forgive these grammatical errors? It'd be a long conversation, Jacob. It'd be a long conversation, I think, for Jesus. Gats, do you think LanDUI has rabies or something? I mean, given he is a drunk dog bite lawyer, could be why he's clearly lost his mind. I don't know, man. I can't figure him out. I can't figure him out because this is so flipping stupid. This is so stupid. Instead of filing the instant cross motion and continuing with his reprehensible conduct, misrepresentations, and defamation, it would have been better for Mr. Greenberger to simply acknowledge that the letters he sent to all counsel of record in this matter, including counsel for plaintiff, missed the mark. But they didn't miss the mark. They nailed the mark. You're an idiot. Recant what he stated and move on to decide the 4 motions to dismiss that are presently pending before this court. Unfortunately, that did not occur, and instead, I threw a giant slap fight fit and started raging like a jilted child. Mr. Greenberger has dug a much deeper hole, comma, for himself. You don't need a comma on either of those, which must be remedied through sanctions and a referral to the Attorney Grievance Committee. No, you file the... Just a minute. Just a minute. I apologize for the delay. I've not died yet. But just a minute. Mr. Greenberger. Just a minute. Amy Peterson says, I want to see a Dick Show and Company Street Fighter style game so you can knock LanDUI out. Might be a good outlet for your rage and not your liver. Gatsgat says, this is clearly an April Fool's suit. Hashtag mildly infuriating. I mean, the fact that he's not joking in this document is offensive. Or maybe, I think Ramos must have written this and submitted it as a joke, right? Like, that's what it's got to be. The judge did it. Okay. Mr. Greenberger is not free to simply lodge any accusation he wishes against a party or counsel for a party, accuse parties in letters and pleadings to the court of criminal conduct, request a party to be referred to the district attorney, and attempt to extort a party into dismissing their complaint against his client. He never asked you to dismiss the complaint. He never asked you to do that. He didn't even hint at it. He said, tell the court that you lied, you liar. Kevin Cartilage said, I may have used hashtag Lawtism in association to you, Nick. Guess we got to keep it for you. All right. Sounds good. Lucifer Love Monkey says, LanDUI is a professional lawyer who I respect and admire. Does saying this hurt? No, buddy, it's April Fool's. I have my built-in trump card. Oh, my gosh. Look at this. Mr. Greenberger's conduct in this matter is troubling to say the least. No, this man has exhibited a ridiculous amount of patience and class in face of what you have submitted, because I mean, he's been funny, but he didn't ask for sanctions until now. Until now. He even gave you an out when you clearly lied to the court and then admitted it. He gave you an opportunity to remediate it yourself. And you could have done so and still maintained that his entire premise was wrong. You could have said, look, we didn't mean to mislead the court in any sort of way. However, it appears that the other attorneys, through not a very careful reading, were misled. And we want to make sure that the court is not misled and that we're very clear, and we have stated from the beginning that plaintiff is Zuni and is Heather S. Why didn't you take that route? Instead, you spurged out like a moron and filed the dumbest document I've seen until this one. He has exhibited an undignified, unprofessional, and completely unethical way of conducting himself, comma, which has no place in this courtroom, comma, or in any courtroom in New York. You don't need the commas. Oh yeah, Iron Maiden. Yes, Lucifer Love Monkey, Iron Maiden, and hopefully LanDUI will run for the hills soon. If Mr. Greenberger is unable to conduct himself in a professional and ethical manner, as any reasonable attorney in the commercial division would, oh, that's rich, you flip, then he should be barred from further practice in the commercial division of this court. You're asking for him to be disbarred from the commercial court? Wow. Plaintiff did not commit fraud on the court. As demonstrated by the foregoing, and as contained in plaintiff motion for sanctions, plaintiff did not commit fraud on the court, and defendant Kokennose's contention is to contrary is appalling and completely ridiculous, without any factual basis or legal support. Defendant Kokennose's fraud on the court argument wholly fails and is frivolous, subjecting him to sanctions under 22 NYCRR 130-1.1. The Court of Appeals recently set forth the evidentiary standard to demonstrate fraud on the court in CDR Creance's SAS versus Cohen. In Creance's, the court held that. Anybody out there watch Seinfeld? I feel like Costanza. Serenity Now. Niels Abel, he recommended that he be prevented from basically disbarment from the commercial division. I'm not familiar with how bar registration in New York works, but they may have specific registration for individual types of courts. We don't have that here in Minnesota. You have just federal court and state court, and then you have the patent bar. So that's it. We don't have different divisions. So I can't comment on it, and since I hadn't read it in advance, I don't know the extent of that sanction. You just got your second doctorate in spicy banter. In order to demonstrate fraud on the court, the non-offending party must establish by clear and convincing evidence. Clear and convincing evidence is something below reasonable doubt, but above more likely than not. Okay, so it's above 51%, below 99%, somewhere around the 70-75% rate area. That the offending, quote, party has acted knowingly in an attempt to hinder the fact finder's fair adjudication of the case and his adversary's defense of the action. Yeah, by claiming that he was someone, that a person that the plaintiff was actually someone else. And by covering up a crime that he committed in perpetration of potentially what could lead to harassment against Asterios. Frankly. Like if Asterios had heard about this, said to Maddox, stop doing it, and then Maddox contacted, Asterios' employer again, that's another crime. That's harassment. But we don't have any evidence that Asterios did that. There's two criminal acts that have happened. Perjury is the court action. And then there's criminal impersonation in the second degree, which was the initial sending of the emails as a person from Condé Nast and possibly as a specific person. But there's more potential criminal activity here. There's the potential for conspiracy. If he talked with Metal Jess about doing this, that's conspiracy, which it seems like he might have because she has a history of harassing other people, right? So there's potential there. And then had Asterios simply said, stop contacting my employer, you bald cuck, and then he contacted them again, then absolutely that falls under the harassment statute from New York penal law. Next quote. A court must be persuaded that the fraudulent conduct, which may include proof of fabrication of evidence, perjury, and falsification of documents, concerns, quote, issues that are central to the truth-finding process. I mean, these absolutely are. You made it look like this was someone else concerned, so concerned about the harassment that Asirios was doing that some outside, disinterested third party contacted his employer and then contacted you. That's what you made it out to look like, but it was actually just you alone in your basement. Essentially, fraud upon the court requires a showing, quote, that a party has sentiently set in motion some unconscionable scheme calculated to interfere with the judicial system's ability impartially to adjudicate a matter by improperly influencing the trier or unfairly hampering the presentation of the opposing party's claim or defense, which you do when you lie in an affidavit about a material issue to the case. Period. 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 Lying about a complaint, same thing. Because complaints, even if the complaint's not made under oath, the affidavit supporting the complaint always is, because you can't submit non-oath truthful statements in a complaint. You just can't. The court can't operate on that. Javier Miedo says, what's more likely, Greenberger disbarment or me having a date with Jamie Lynn Hughes? P.S. Does LanDUI mess up more with law rules or his grammar? I think you having a date with Jamie Lynn Hughes is more likely than Greenberger being disbarred in any way. Like, that's a hollow and empty threat. It's just offensive that he would put it in there because, these documents are public, right? Like, I made fun of Landau for all his DUIs, and I've got another video coming out making fun of how badly he represents his clients in several cases. That's still coming, pal. Now Greenberger's got a document out there that suggests that he should be disbarred for his unethical conduct. And while he'll ultimately be vindicated in that, it's ridiculous that he even has to address such an absurd statement just because the other counsel that happened to be representing someone in this case is a flaming moron. Pardon me. I need to calm down. Do you guys know that I'm literally allergic to being angry? I might not have said that before. So, here we go. Here, as demonstrated by the foregoing, plaintiff has never attempted to hinder defendant's defense of this action. Oh, that's rich. Like when you filed a frivolous motion to try and get the court to put an injunction on the entire internet from saying the word Maddox or from saying Landau is a drunken sauce dogpile attorney who can't drive. He can never drive again because he drinks and drives so much and is such a menace to the earth that the court had to stop it. They had to step in and say, whoa, buddy, you're going to murder like an entire family and we can't have that on our hands. Because you can't breathe into a device while your car is operating. Because you register positive for alcohol use after starting the car. Okay. Or the fair adjudication of this case in any way, nor did he commit perjury or falsely any evidence or documents. It's falsify. Edit your documents. Further, Koch in Nos never raised any issue related to Plaintiff Azunian identifying himself as Heather in his motion to dismiss because he hadn't admitted to it yet. Which he filed on January 6th, 2018. He didn't admit to it until March 8th. That's 2 months prior. He is not a time traveler. And which is presently pending before the court. Further, in his complaint, Plaintiff Azunian pled and identified himself as Heather, the reporter that exchanged emails with Weber Shandwick relative to defendant Kokonos' actions and conduct towards plaintiff. Go ahead. Just lie to the court. Just keep lying. Actually, yeah. I changed my mind. I told you in the first or second, I can't even remember, one of those two videos, I'm like, you shouldn't lie to the court because lying to the court is bad. Really, really stupid thing to do. But go ahead and keep doing it. Let's see how that works out for you. Which Kokonos intentionally omits. Okay, wait. That he identified himself as Heather, the reporter that exchanged emails with Weber Shandwick relative to defendant Kokonos' actions and conduct towards plaintiffs, which Kokonos intentionally omits from his instant cross motion and fails to bring to the court's attention. Now he's cited to 197 and 198. Let's see what 198 is. Oh, it's just an absolute mistake. Because this guy is so bad at drafting that he gets his own citations wrong. It's 196 and 197. 198 says, as such, plaintiff sustained in plaintiff's apostrophe. You cited your own error again. God, you're an idiot. Sustained substantial injuries and damages as a proximate result of Weber Shandwick's inaction, acquiescence, and negligence. You're so stupid that it's pathetic. I had nice words for you in the last stream. I don't anymore. I hope you fail your MBA. Or I hope you get your MBA and run someone out of business with it. That'd be great. And then I hope you get sued. Moreover, plaintiff Orangutan submitted an affidavit in this matter in response to Weber Shandwick's motion to dismiss, identifying himself as Heather on March 8th. On March 8th. Hold on. He's saying docket 101 exhibit 3. Is that the March 8th document? Let me check real quick. I just want to make sure. Yeah, that's the March 8th document. Okay. I wouldn't want to misrepresent him. Gatscat says, does LanDUI confirm everything the public believes about your profession to be true? The more you read, the better I feel about my bet on Maddox. Yeah, absolutely. I mean, he's embarrassing. He's embarrassing and infuriating. Guns Beer Freedom says, to be fair, he cites his own errors every document, which he refers to the initial complaint. Yeah. Have you guys ever seen the movie Defending Your Life with Al Brooks, where he dies and he goes to like the purgatory place and he has to justify his passage on into heaven, or else he gets like reincarnated and has to try again at life? Like, I think he can cite to God's mistake when he cites to his own birth certificate. Finally, counsel for plaintiff explained all of the foregoing and identified all the foregoing documents, pleadings, and statements in a comprehensive letter sent to Mr. Greenberger. I don't think you mentioned these complaint citations at all, actually. I'm pretty sure you didn't. I read those letters. I don't remember them that well. On March 13th, 2018. Further, all of the foregoing documents and statements were annexed to or referenced in plaintiff's motion for sanctions filed on March 14th, 2018, which Mr. Greenberger fails to refer to or respond to in his present cross motion. I mean, that is rich. That is rich. Ugh. Plaintiff should not be sanctioned. However, Greenberger and defendant Kokono should. Good subheading, buddy. I guess this isn't even responding to Munoz's motion. That's depressing. As demonstrated by the foregoing and in plaintiff's motion for sanctions against Mr. Greenberger and his client, defendant Coke and Nose, was sound, factually supported. ED. I'm sure you're familiar with it with all the drinking. Add an ED. Bilkin Irons. Any chance a judge reading without our background knowledge might be swayed by LanDUI's confident wording despite being so wrong? I can't. It's always possible, but I can't imagine it. Reek says LanDUI defense under influence. Oh. Okay. Let's see. As demonstrated by the foregoing and in plaintiff's motion for sanctions against Mr. Greenberger and his client defendant Coke and Nose was sound, factually support, and based on Mr. Greenberger violating the professional rules of conduct and engaging in you have tense disagreement within this sentence, and probably because it's like 14 sentences that you've just decided to tack commas onto haphazardly and make into one. But you have tense disagreement all over the place. And engaging in frivolous and appalling conduct, subjecting him to sanctions and possible referral to the Attorney Grievance Committee. Cats, why even use a glass? Toss one of the bottles in a bag. At this point, man. At this point. Plaintiff's motion was supported by the facts, the ethical rules of conduct, court rules, and case law, which Mr. Greenberger simply fails to respond to. That's because literally all of it is wrong, and he did respond to it. And omits from his present cross motion. No, he addressed it in the first part. And then he gets to the cross motion where he no longer needs to address it because it's a cross motion and he's talking about a different set of facts. And rules and case law cited therein. Wait. Oh, see the docket. Okay. And he cites all of his cases that have been thoroughly debunked by both sides. I can't read them. I'm too mad. Are you serious? Another document is being processed midstream? That better not be an April Fool's. If that's an April Fool's, I'm going to find you. I will check it out. If it is, we're going through it. We're plowing straight through. The case law cited by defendant Coke and Nose actually supports imposing sanctions against Coke and Nose and Greenberger in this case. Not at all. Not at all. In Yinam Corporation, like counsel for plaintiffs here, he wrote Greenberger a letter fully explaining how baseless his position was and that sanctions would be pursued if he continued to press his frivolous position. Phone Losers of America says, seems pretty obvious that Maddox kidnapped LanDUI and has been running the whole case himself. I mean, at this point, it kind of looks like it. Greenberger did that very thing, responded to plaintiff's letter, and doubled down on his accusations of criminal threats and grievances, which necessitated the motions for sanctions. Necessitated. I'm going to go through your history of motion for sanctions, you flipping coward. You try and silence every single opposing party with a motion for sanctions somewhere in your stupid filings. A new filing is being processed right now, confirmed. Good. We will bring it up on stream in just a minute because we're almost done with this one. See Yenam Corp. Here, before the motion court issued its orders, the C. Rights defendant's attorney wrote to plaintiff's counsel demanding that the frivolous complaint be withdrawn, but plaintiff rejected this request. Thus, plaintiff's counsel was well aware of the fact that sanctions might be forthcoming if this action was pursued. The other case cited by defendant Coke and Nose in his cross motion is substantially similar to conduct engaged in by Mr. Greenberger in this case against counsel for plaintiff and plaintiff himself. And in filing the instant cross motion, which is based on misrepresentations. Memorandum of law in opposition to cross motion and in further support of motion. Motion number 6. All right, that's the Munoz response, and we will read it. Can LanDUI plead insanity? At this point, I mean, they're going to have to implement something new for him. Maybe the court can have him recommended for a psych check. And is completely frivolous and further accuses plaintiff of committing felonies. Perjury is singular. And requests the court to refer plaintiff to the district attorney's office. Yes. Yes. They should. After this, they should twice. See Turjak versus Turjak. Award of $5,500 to father's counsel against mother's attorney was appropriate. Sanction for attorney's frivolous motion to impose sanctions and costs upon law guardian. I don't know if you realize, Landau, that this is condemning you, not them. And costs upon law guardian, father's counsel, and child custody proceeding. Motions were completely without merit in law or fact, were made primarily to harass and maliciously injure another, and were supported by affidavits from doctor that were rife with unfounded, gratuitously offensive, and utterly unacceptable attack on father's counsel, law guardian, and family court. Mons Deslaya says, can LanDUI plead April Fools? He better hope so. Whoa, I remember that game. What exactly is happening in the court on April 2nd, assuming things don't get postponed again? They're ruling on these two motions, the sanction motions specifically, for Asterios and Weber-Shandwick. That's what's going on tomorrow if it doesn't get delayed. And man, I hope it doesn't. Man, I hope it doesn't. I don't know. I don't think I'll be able to live stream, and I don't think we're going to have anything to live stream tomorrow because if anything, it'll be a short court order, maybe. But if we get something longer than short, I will try to find a way to make it work. But I'm going to be really busy tomorrow, so I don't know what's going to happen there. Similar to Turjek, here, a financial award to plaintiff and his counsel against defendant Coke and Nose and his counsel Greenberger is an appropriate sanction for Greenberger's frivolous conduct and frivolous cross motion, which is completely without merit in law or fact. and made primarily to harass and maliciously injure another, and is rife with unfounded, gratuitously offensive, and utterly unacceptable attacks upon plaintiff and his counsel. Did you Google adverbs or something and learn about them? Oh my gosh, you're just weak writing. Mr. Azunian should not be referred to the district attorney's office. However, Greenberger should be referred to the attorney grievance committee. There you go. There you go. As demonstrated by the foregoing and in plaintiff's motion for sanctions, this request by Mr. Greenberger and defendant Kokinos is beyond the pale, is completely without merit in law or fact, and made primarily to harass and maliciously injure plaintiff, and is rife with unfounded. Guys, it's like LanDUI just passed 8th grade English, like with his little flourishes. You're not a good writer. You're an embarrassingly bad writer, actually. As indicated in plaintiff's motion, this type of conduct has no place in this case or in any civil case or litigation in this court. It is unethical and frivolous conduct meant solely to harass and gain advantage in this case, which violates the rules. You said this earlier, and you're still wrong. Thanks, Gabe Benitez. You're the prettiest man I may have ever seen. See the Code of Professional Responsibility, Disciplinary Rule 7, which you already said. I'm not going to read that again. I'm not going to do you the dignity of reading your copy and paste over and over. The case cited by defendant Kokinos is misrepresented by Kokinos. However, it may have application to the instant case in one important aspect. In River Bay Corp versus Houston, the person referred to the district attorney's office for an investigation was not a party to the case, but instead was a city marshal who violated the standards of integrity in the management of his office and the conduct of his official duties by lying under oath in open court. You don't have to have a party to a case to be wrong to lie under oath. And complaints and pleadings are in open court. They are in open court. They're actually worse because you have time to edit. It's not a mistake when you put it in a complaint and then sign an affidavit that says, yeah, I actually read what I told my attorney to write, and then I decided it was still correct. It's worse than open court. You're lying in the pleadings. You may not even get to open court depending on what's in the pleadings. So lying in the pleadings is about the worst thing you can do. Alan Foster says, I'm way prettier. Well, buddy, don't send nudes. But hopefully I'll find out at a road rage and we can have a competition. However, in River Bay, unlike the instant case, the court noted that it did not have the authority to discipline the city marshal. It did find his conduct unacceptable. Here, the court does have the authority to discipline Mr. Greenberger and commence a grievance against him for violating his ethical duties and impugning the integrity of this court. That is the richest thing you've said so far. Wherefore, plaintiffs respectfully request, no S, that the court grant their motion for sanctions in its entirety and award sanctions against defendant Kokinos and his counsel Jordan Greenberger in the maximum amount of $10,000 in reasonable attorney's fees and costs in the amount of $7,500. Plaintiffs further pray that the court deny defendant Kokinos' cross motion in its entirety and refer Mr. Greenberger to the grievance counsel for the First Judicial Department. You are scum. You are oh my gosh, you are just... Hold on. Give me just a second. I'm pulling up the other document. Since it came midstream, you'll just have to give me 1 minute to get it downloaded and pulled up on OBS. This one is... Okay, hold on. Here we go. Okay. It's like we had a couple things come in. You're too hard on LanDUI. You're both men of law. You jabberjaw. You go tit for tat. You have little differences. But at the end of the day, bird law in this country, it is not governed by reason. No, I'm not going to... I cannot... I've been very deferential in my opinion of LanDUI to this point. Believe that or not. This guy is awful. Albert Dickbutt just had sex for the first time. Okay. Thank you for that, Tanu Bojangles. I appreciate that. Mumkey, that is a possibility at this point. Like, it almost has to be. It almost has to be. That he's a Dick Show fan, making Maddox lose on purpose. And I reiterate, Maddox, if you have the stomach to watch me make fun of your attorney endlessly and pretty much make fun of you at the same time. If you have the dignity, please consult counsel. I don't know what you and LanDUI have discussed. I really don't. But my God, if he advised you to lie about being Heather, if he advised you to then admit to perjury, if he advised you to all of these things in the way that it's been done, you really need to consult an attorney. You need to. You need to. Okay. All right. Let's do this. Here's the next document. We're going straight in. Defendant Weber Shandwick's cross motion and opposition papers are untimely and must be struck. Defendant Weber Shandwick's cross motion in opposition to plaintiff's motion for sanctions is untimely in violation of CPLR 2214 and CPLR 2215. Let's see what it says. A notice of motion and supporting affidavit shall be served at least 8 days before the time at which the motion is noticed to be heard. Answering affidavit shall be served at least 2 days before such time. Answering affidavits and any notice of cross motion with supporting papers, if any, shall be served at least 7 days before such time. If a notice of motion served at least 16 days before such time so demands, whereupon any reply or responding affidavit shall be served at least 1 day before such time. Okay, let's just go back to it. Let's go back to it. Hold on. You'll have to... I can't do it. Here we go. Okay. Guys, take just a moment and look at how sociopathic, schizophrenic, and idiotic this guy is. This is his document. Here it is. Respectfully submitted from the LanDUI group. Please take further notice that pursuant to CPLR 2214B and 2103B, reply papers, if any, are to be served so as to be received by the undersigned at least 1 day prior to the return date on this cross motion. The return date is right here. The 2nd day of April at 9:30 p.m. because you're such a freaking idiot that you can't write a.m. because court is not open at 9:30 p.m. In your own document, you gave them until today. Okay, so sorry. Guys, my brain is breaking. My brain is it's falling apart in the wake of this chaos. He says, I missed the Reberger part of the stream. When did the Shandwick document drop? It dropped 15 minutes ago, something like that. Okay, let's get back to this. So here's what they're saying. Then CPLR 2215 states at least 3 days prior to the time at which the motion is noticed to be heard, or 7 days prior to such time, if demands are properly made pursuant to subdivision, a party may serve upon the moving party a notice of cross motion demanding relief with or without supporting papers. Answering affidavits shall be served at least 2 days before such time. Answering affidavits and in any notice of cross motion with supporting papers, if any, shall be served at least 7 days. If a notice of motion served at least 16 days before such time so demands. Reek says, a second document, you should set up an at-home breathalyzer with a counter next to your face in the corner. This is ridiculous. This is just ridiculous. Neil Zabel says, Nick, please drink for your health. I'm gonna pause a minute. Gatsgat says, Judge Harry Stone hears cases at 9:30 p.m. Okay. Here, let's just go ahead and so we'll unfortunately there's this little internet personality who takes brutal offense to the fact that Maddox is the saddest person on earth. And he likes to come into my streams and try and sew up stuff and tries to make videos about me. Great. Okay, I guess. Here's the problem, pal. I don't care about you. That's it. Keck7 Go says, which you hate the most, LanDUI, cops, or liberals? Man, I try not to hate anybody, in all honesty. Try not to hate anybody. Even salty Maddox fans who harass me constantly. But, yeah. Let's get into this. Let's see what backwards argument this dummy has. Who is it? Who is it? I don't know. Someone who has some issues. Tyler Friedberger says someone who knows nothing about the law. I'm not saying I agree with it, but bird law is very messed up in this country. There you go. No, Mumkey, Maddox doesn't have fans. Maddox pays people to do his fighting for him. And I think you probably know who that is as well. But I don't know. You can check it out. He's really sad. Here, plaintiff brought a motion for sanctions on March 14th, 2018, included a CPLR 2214B demand in his notice of motion, and a return date on plaintiff's motion was April 2nd, 2018. However, defendant Weber Shandwick filed their opposition and cross motion on March 30th, 2018 at 4:17 p.m., right before sundown, before Passover started in the Easter weekend. Therefore, defendant's filings were untimely. No, they're 2 days before. Actually, they're 3 days before? So you got 30th, 31st, and then 1st and 2nd. And cannot be read in opposition to plaintiff's motion or as a cross motion. You don't need a comma there. Therefore, defendant's filings were untimely and cannot be read in opposition to plaintiff's motion or as a cross motion. That's not correct. Further, counsel for defendant's conduct in filing an opposition and cross motion on the eve of Passover and before Easter weekend is classless and unprofessional. And you set the motion date for the day after Easter. You set it. You wrote it down. You chose it in your motion. You did it intentionally to narrow the window for them to respond. And representative of Mr. Munoz's other conduct in this litigation. This man is an altar boy. And counsel for plaintiffs doubts that Mr. Munoz has never been the subject of a motion for sanctions. You can doubt it. Why don't you? In his entire career, as claimed by him in his affirmation. You doubt it because you've been the target several times, I'm sure. Notwithstanding such filing by Mr. Munoz, which should be the subject of sanctions in and of itself, it also violates CPLR 2214B and CPLR 2215. Sure it does. Refusal to accept the plaintiff's responding papers served the day before scheduled hearing on motion to dismiss was warranted. It wasn't the day before. It was 2 days before. We have e-filing now. You don't... Where defendant had served notice of motion by mail at least 17 days before return date, thus requiring the plaintiff to comply with the defendant's demand for service by answering papers at least 7 days prior to the return date. You didn't make the demand. You didn't make that demand in your own papers. You didn't make it. It's required under the rule that you make it, and you didn't. Particularly since plaintiff failed to submit valid excuse for lateness. See Fort Tyron Nursing Home versus Kavanaugh, where defendant's papers in response to the plaintiff's motion for summary judgment were not served until day before motion was to be heard. They could not be read in opposition to motion for summary judgment unless good cause excused neglect. As such, defendant Weber Shandwick's opposition paper. When were these filed? Let's see. LanDUI was filed on the 14th. Guys. Whoops. Sorry, wrong document. Seriously. I need a moment. Okay. As such, defendant Weber Shandwick's opposition papers and cross-motion papers must be struck and not read in opposition to plaintiff's motion for sanctions. Sure. Sure, pal. Notwithstanding the foregoing, if the court does not strike Weber Shandwick's opposition papers and cross-motion, then Weber Shandwick's cross-motion should be denied largely for the reasons stated in plaintiff's motion for sanctions and the reasons that follow below. Plaintiff respectfully submits this reply memorandum of law in further support of their motion for sanctions, costs, and attorney's fees, and in opposition of defendant Weber Shandwick's cross-motion for sanctions. Like, honestly, dude, you can't raise this issue because under your logic, you would have to strike your response to Greenberger. You'd have to. If Weber Shandwick's filing is untimely, your reply filing is untimely. Similarly, especially considering you filed at like 8 p.m., 9 p.m. Eastern. They filed on a business day during the business day. Keck says, could and should Maddox consider hiring Greenberger? I don't know if he could. He should consider it if he can. Okay. All right. So, factual background. Let's see how this goes. So you want me to talk to you? I don't want to talk to you. Super chat me if you want me to talk to you. All right. Plaintiff refers the court to his statement of facts in the letters and affidavit annexed to plaintiff's memorandum of law in support of his motion for sanctions, dated and filed on March 14th, 2018, which is incorporated by reference as if stated in full herein. In an attempt to cover his own unethical and disingenuous conduct, defendant Weber Shandwick and their counsel Michael Munoz have decided to file a cross motion and response to plaintiff's motion for sanctions, which temper Munoz's previous threats and accusations of plaintiff engaging in criminal acts and accusing his counsel of engaging in unethical conduct. As indicated in plaintiff's motion, Munoz's initial conduct has no place in this case, or in any civil case or litigation in this court. It is unethical and frivolous conduct meant solely to harass and gain an advantage in this case, which violates the rules of professional conduct and the rules of this court. This is the same argument he used in the last document. Further, it is clear from Munoz's cross motion in opposition that defendant Weber Shandwick have not read plaintiff's motion or plaintiff's complaint. Mr. Munoz fails to point to any statement that either plaintiff or his counsel made that plaintiff Azunian was not the Heather alleged in the complaint who sent emails to defendant Weber Shandwick. Instead, Mr. Munoz refers plaintiff and the court to plaintiff's complaint to substantiate his baseless accusations that plaintiff somehow misrepresented things relative to the Heather alleged in his complaint. Since we're copy and pasting our other motion here, let's see if he accidentally leaves in Greenberger instead of Munoz. Plaintiff Orangutan did not allege that he was Heather in paragraphs 64, 69, 73 of the complaint, which is the problem with the entire premise of Mr. Munoz's misrepresentations to the counsel and the court. Like, you copy and pasted your own wrong paragraph. You're saying that George did not allege that he was Heather in those paragraphs. That's the problem. He's misrepresenting it. Because plaintiff Azunian alleged that he was Heather at paragraphs 196 and 197, which he absolutely did not do. Fahuku God 7 says, nobody'd fault Munoz for breaking his pattern of professional conduct and breaking a chair over LanDUI's head tomorrow if it didn't count as dog abuse. Mr. Munoz acknowledges this and indicates in his cross motion that plaintiff actually submitted an affidavit in response to Weber Shandwick's motion identifying himself as Heather. Your Patreon link is starting to burn into my plasma TV. Do I have a case against you? Nope, not at all. Fight me, bro. Mr. Munoz's accusation of plaintiff and his counsel are therefore patently unethical and defamatory, and he is completely wrong and mistaken. Guys, he copy and pasted his own document. This is the exact same. I'm not going to read through it all unless I see something new. Here we go. I called it. Look at what this idiot did. Copy and pasted and forgot to change Greenberger to frickin' Munoz. Oh no, he added Mr. Munoz. Okay, never mind. Sorry, I got too excited. Like his accomplice, Mr. Greenberger. So he just added and Mr. Munoz here. Oh, now Mr. Munoz needs to be referred to the grievance committee. Okay. He just literally added and Munoz after every Greenberger. Plaintiff should not be sanctioned. Okay, however, Munoz and Weber-Shandwick should be. Why are you leaving all of Greenberger and Kokonos in here? Like, you should take that out. Gosh, oh, this is... Let's all not disguise ulterior ideas in some reactionary environment. The award requested denotes extraordinary dementia. Read the first letters. Yes, yes. LanDUI is retarded. The case law cited by defendant Weber-Shandwick Munoz, like the case law cited by Kokonos Greenberger, actually supports the imposing sanctions. I wonder if they even cited the same case law. It's the same thing. It's the same document. He literally added and Munoz after all the Greenbergers. Good job, you freaking idiot. They have different arguments in their motions. I hope that comes back to bite you. Why did it take you 2 hours to do that? All right, guys. All right. Let's, I'm not going to go ahead and read this. He requests the exact same thing. It's literally the same filing outside of the first paragraph or so. And then, he just adds and Munoz after Greenberger. Just sad. Okay. So we'll open it up to questions. So go ahead and ask them. Have fun. Yeah, I think he may have forgotten that Munoz also submitted a document. Find and replace is hard when you're as drunk as LanDUI. Sure seems to be. Sure seems to be. I don't know why he did find and then add after. But it took 2 hours because that's how long Maddox took to explain Control F to Landog. How are you able to not hate when there are scumbags as wretched as Kevin Landau in the World Series question? I didn't say I'm able to not hate. I said I try really hard not to. Brace yourself for 3 minutes of last-minute filing. Does it cost $7,500 for a lawyer to copy and paste a document? I mean, I think there's serious questions about that. What are the chances that LanDUI and or Maddox get sanctioned? I mean, like I said before, is stronger with every document. If you had to choose between having LanDUI defend you in court or random dickhead, 10 times out of 10. Mumkey Jones, because a random dickhead probably wouldn't advise me to commit a felony. If the case is dismissed by the judge, can Dick and Asterios get all their lawyer fees paid by Maddox? That is a possibility. We will have to see what the court has that in their power to do so. And I think with every single misrepresentation that keeps coming, that is more and more likely. LanDUI billed Maddox for $7,500 for these two documents together or separately. That's unclear, isn't it? But it sure looks like it should be billed separate, or it shouldn't be billed for that much at all because this didn't take $7,500 for him to do. But that's kind of what he's talking about. Is it child porn to have naked pictures of your underage self? That's a good question. Maybe I'll do a video on that because that's a pretty good question. I think it's pretty pertinent in the age of teenagers and sexting. So I'll have to refer, I don't want to give you the wrong answer, so I'm going to have to hold off on answering that. When I copy paste, the last line says attorneys for plaintiffs names. It comes out as attorneys for plaintiffs on pasting. Did LanDUI hide the word plaintiffs in the Word document? I don't know. And I don't know why he would. Would you represent Maddox in going after Landau? I'm not admitted to the bar in those, I'm not admitted to the bar in any of the states that it would be relevant. So I couldn't help him. LawSuit settled with Nick/LanDUI drinking contest. He'll win. You don't want to do that. Do cases dismissed this quickly ever get cited in other cases, set legal precedent, or does it have to go further? It usually has to go further. They can get cited in cases as, but they're not going to be authoritative. They can be informative, but usually they're not published cases, and so the citation rules are pretty specific around them. Usually you're at the appellate level before you're setting legal precedent. If you had to choose between having LanDUI represent you in court and having Kevin LanDUI drive you somewhere, what would you pick? Ooh, one results in financial ruin and the other results in death. So, I don't know, man. What is the likeliness of you getting served or sued for slander by Ruff family? I mean, LanDUI family. Low. According to bird law, 3 strikes and you're out. Bye-bye, birdie. Heather S. Would the court allow me, I mean George, to play your videos in court to prove how mean and hateful your harassment of him is? I doubt it. They're way too long for court. Where would we check for the status of tomorrow's court hearings, assuming Dick and Asterios don't tweet about it? You can check at LoLsuit.com. If the judge issues an order, I assume it will be filed, and the user who files it will be listed as court user, probably. So you can check there. I'll probably talk about it if I find out anything else about it also. But like I said, I'll be pretty busy, so who knows. Will the court take this April Fool's joke well, or will they be upset? They'll be upset. What are the chances Munoz or Greenberger respond to this before the hearing? 0. There's no point in doing that. I think LanDUI in paragraph 196 stating that Weber failed to protect plaintiff's privacy is his evidence they identified Maddox as Heather. I mean, that's what he's trying to say. But they would have to know that Maddox was Heather. And we don't have any information or emails to suggest that they do. All we have is Asterios' tweet where he figured out that it was obviously Maddox. But the court doesn't know that. And the court's not going to get that either. I have no legal training and can better understand his thought process. Yeah, I mean, that's what he's trying to say, but it's not strong. Will the lawyers bill for everything, or at a certain point will they stop in reference to this stuff as it's more of a slap fight between the lawyers? No, they're gonna bill for everything. Knowing nothing about me, am I a more competent lawyer than LanDUI? Let me check the 8-ball. Odds point to yes. Thanks very much, Tim Cower, for the super chat. You don't have anything specific to say. Will LanDUI file sanctions against the judge? At this point, I put nothing past him. Hamilton says, just up my Patreon because I want more rackets. How late can LanDUI file these documents before the judge chastises him for untimely filing? I mean, I don't know. Technically, he's less than 24 hours before the hearing, but he is the filing day before the hearing. Electric filing messes up timelines, so it's kind of hard to say, and I'm not familiar enough with New York stuff. But what I will confidently say is, if his argument about Munoz's filing is true, then his argument against Greenberger's motion is similarly deficient. If I recall, there was a case where a teenager was charged with distribution, possession of child pornography of himself. Don't know where it went through. He was sexting, of course. Yeah, I'll be looking into that. Sorry, Britt here. Is there a bar standards board where LanDUI can be referred for serious misconduct? How does the conduct complaint system work across the pond? Typically, those conduct complaints either are referred by the court or they would be brought by someone who had hired the attorney. That's who typically has the ethics claim. Or they would be brought by another attorney with knowledge of those facts. An attorney registered in that forum. Peruvian Pastry asks, have you ever seen an equally or more one-sided case where the court ruled the unexpected way? No, I haven't. Someone says, I love you, Dad. Okay. I didn't know my kids were on the stream. How much does grammar affect court documents? How much is Grammarly worth to LanDUI? Grammar affects court documents because it makes judges angry. That's all. And you don't want judges angry with you. So you don't want to make these little mistakes, because these little mistakes might annoy them enough to bring their attention to bigger mistakes, like lying to the court. Whether Maddox will win or lose Can or should all parties, Patreon included, sue Maddox in return? Some of them may want to consider it, but they'd have to have specific causes of action. You can't sue someone because they sued you unless there's a specific statute like an anti-slap. And New York has one. It's not very strong, but it's possible in this case. Otherwise, there are other remedies. These sanctions are basically a countersuit. Will the copy-pasted content in the second motion be looked down upon by the judge, or does this sort of thing regularly occur? I mean, copy and pasting occurs all the time. The fact that they copy and pasted the entirety of the argument without addressing any of Munoz's specific stuff is a problem. Did you come across anything that requires oral argument for motions involving sanctions? I'm assuming not. No, I haven't come across anything, but they, we'll see, I suppose. There's a couple, hold on. Kevin Flesher says, the more I drink, the easier it gets to understand LanDUI's writing. Also, Nick, what's your favorite hobby? What's the fastest you've gone on a road? Fastest I've gone on a road was probably 106, I think, because I was in a 4-cylinder car. Took a while to get there. Tim Cower, this makes me feel like I'm tipping a cam girl. Well, whatever suits you, buddy. Gats, these videos turn me on more than most cam girls. Okay. Let's see. Hold on. Let's see. I just looked at the timestamps. It's 3 hours apart or so. Does that mean factor into processing time, or is it time difference between filing? That's time difference between filing. Did you ever pick up Dragon Ball FighterZ? And if so, which server can I blow you up on? I haven't picked it up yet, but I'm going to soon. Will LanDUI file a document in court? Which document? Any chance Ramos has briefed this case, seen it as a mess, and postponed Asterios and Dick so they can dismiss it all in a cross motion and saving the court a bunch of time? It's possible. I don't know why they postponed those initial hearings, or that initial hearing. So it's said. How many books of mocking children's artwork will Maddox have to sell to afford all these legal bills? Infinity at this point, because he may have only released a bunch of unlicensed artwork without permission from those children or their parents. Could they submit a document that just says in before lock? No. Do lawyers ever submit a corrupt PDF to get an extension? I don't know. I mean, I guess they might. That's a possibility, but it seems like you just submit it within the timeline or request some extra time. Sorry if you've answered this previously, but can Maddox appeal if/when his claims get dismissed, or would he have to try and refile elsewhere? No, he would probably have to appeal he'd have to appeal the dismissal rather than refiling. Just woke up. Did you miss much? Only all of it. You shouldn't say you'll be looking into teenagers sexting pictures of themselves. That'll make a bad soundbite. Lawyers make bad sound bites all the time when they talk about what they do. What weight does the truth versus good lawyering matter in the typical case? Good lawyering is the truth. I mean, it just is. No matter what you think, good lawyering is the truth. Because when you lie consistently, it's eventually going to come out and things are going to get worse. I might have to drop the ban hammer on someone in the chat. I mean, why keep doing it? I mean, I can keep banning him and he can keep coming back with alts, or I could just ignore him, I guess, because he's dumb and pointless. And, that's just how it goes. Do these defendants' other non-countersuit remedies involve asking the judge to make the plaintiffs and their counsel fight them? Yes. You can ask. It might not happen. When is Dick's hearing postponed until? It's May 2nd, I think. From a layperson's POV, this looks like a LanDUI is throwing everything on the wall and seeing which sticks. Is this strategy effective IRL? Happy Easter, by the way. Happy Easter back to you, buddy. The kitchen sink approach is effective in some way, not in the way he's using it. Like, you are required to bring all of the... You're required to bring all of the issues generally in your initial complaints or your initial motions. So that's kind of the kitchen sink approach, and you argue them even when they conflict. That's a thing that happens. But, in this case, it's he's trying a bunch of other stuff. I don't even know what to call it because it's just so stupid. I accidentally submitted a corrupt PDF once and did get an extension. Yeah, I think if you're charming enough and convince people that it was an accident or have it actually be an accident, you know, then that's great. So Great Dolomite says, long-time listener, first-time donator, keep up the good work. That's a lot of commas, buddy. A lot of commas. Do you have a good estimate when this lawsuit will get settled? No. I'm hoping May 2nd when they have that hearing, but it's possible. How would you recommend finding a good lawyer? I mean, you just got to talk to them. You got to talk to several attorneys. Find the person who you trust. In all honesty, like that's because when you're, no matter what you're involved in, no matter how innocent you are, you need to sit down and tell someone honestly every fact of everything, and you have to be willing to trust that they're the guy you tell it to. That's it. Is that teenager case the one where the police got a court order to chemically induce an erection so they could compare it to the phone's pics and prove it's him? That was crazy. I don't know. That's hilarious if so. Oh my gosh. Let's see. At what point does frivolous motions does the court throw someone in jail? I mean, they could throw someone in contempt, or they could hold someone in contempt for this stuff, but probably not. They'll probably just go ahead and sanction them for money, because that's worse. Okay. Does it seem like LanDUI is gravely serious alcoholic and that is what is prompting his insane responses? Maybe, man. It might be. LanDUI claimed that Munoz and Greenberger were working together. How is that bad? Even if they were, I would think the defendant's lawyers communicating with each other would be a good idea. It's not necessarily bad or good. It can be an ethical problem if the parties have adverse claims. And in this case, Weber Shandwick may have an adverse claim with Asterios, because if they say, yeah, we found out Asterios was recording on our equipment and he didn't have any authorization to that could be a defense to them condoning his activity. If we didn't know about it, you know, we didn't know he was doing this, but he was, and we have a policy against that and he violated that policy, maybe that is. They haven't done that yet. They haven't done that. They might not, but they potentially have adverse claims, so there could be an ethical concern there. I think he's just grasping. On the subject of child porn, is it still child porn / illegal if you Photoshop a baby face / minor's face onto an adult's body, legally speaking? In all honesty, I don't think so. But it's a weird case when you have technically not a minor, but made to look like a minor, that treads into strange waters. And maybe if I do that video, I'll cover that as well. But they don't really have the best rules on this stuff. They're not very clear. Their child porn rules really should be cleared up and modernized to not get like a teenager who sends a nude to their significant other registered as a sex offender. That's a little too far. Do you think Asterios is writing jokes for Greenberger? I have no idea. All right, guys. That's where we're coming to an end of the stream. Unless there's any more questions last minute, I'm going to wrap it up here because it's still Easter. I want to get back to my evening. I really appreciate you guys coming out for the stream. Tons of fun. Really happy that we have so many viewers on this. Other people do live streams and don't get quite so many views, so that's great. I really, really am thankful that you guys are supporting me. Oh, is the stream dying? No. What do we got here? Okay. Let's see. Furious Freeze. Prove God exists in 30 seconds or less. No, I don't need to. I don't want to prove anything about that. That's not how I do things. I'm sorry for child porning up the stream. It was an honest question. No, it is a good question. It's a really good question. In the modern age when kids are getting cell phones as young as 11 or 12 or earlier, I guess some people, I have no idea like how the court is going to navigate it. And the court is always years behind on technology issues because tech moves faster than old people. Not a question, but I need you to go back to your worst microphone. I can hear you drink that beer, you heathen. All jokes aside, I love it. Keep up the great work and free entertainment. Thanks, buddy. Really appreciate that. Any predictions on who, if any, will countersue after this is decided? I choose not to say anything. I don't actually have any predictions, and I don't want to say something as a joke and have it come out and have people like insinuate that I know something. I don't. I have no idea. So let's see what's coming down the video pipe. Also, pimp your Patreon. Yes, patreon.com/Lawsplaining. Other way. It's other way every time. It's right there. Go check it out, please. Also, patreon.com/Asterios. Support him because there's a bunch of whiny little pansies on the internet who really got their feelings hurt and decided to sue him, and they really should not have. He doesn't need to be involved in any of this. Don't let LanDUI turn you into an alcoholic yourself. Not a chance. As for what's coming down the video pipe, I don't know. I don't know at this point. There are a lot of topics out there, and I can't think of all of the ones that I've got kind of docketed. But apparently child porn is coming down the video pipe, and not in the way where I'm going to be releasing child porn, but child porn as a legal subject. So we'll see what happens. If law enforcement found drugs on a rental or Lyft, how liable would the driver be? They would have to make a case that it wasn't theirs, and it would really depend on who they could pin the blame on. Is writing legal doc in Comic Sans good lawyering? No. How much will we need to fund you for another child? Oh, I don't know, man. We'll see what happens there. Happy Easter and cheers to you. Same to you, Mr. Kill Everything. Christus resurrects it. Are esports real sports? No, they're not. They're a different thing, right? They require an unbelievable amount of talent and an unbelievable amount of time investment. But no, they're not real sports in the sense that sports are different activities. Is there going to be any more Google drama? Yes. Oh, there's okay. 2 videos that are coming down the stream is one, the Tim Chevalier Google suit. He's the guy who threatened James Damore in a private email, was later fired after Damore was, probably when Google realized what trouble they were in. And then the class action lawsuit of women, the women filing against Google, and we'll contrast it to Damore's class action lawsuit as well. So those are definitely coming down the pike. Do you think LanDUI had all these responses pre-made and was going to send them regardless of what Greenberger and Munoz submitted to the court? I really don't think he did. I don't think he did at all. All right, guys. Am I going to pass this semester of classes? I mean, if you work hard enough and do well. All right, guys. I'm going to blank out the screen. I really appreciate everything. Of course, again, thank you for coming out, and we will talk soon. So you have a good night. Enjoy Easter with someone important. Even you, Mr. Angry Person in the chat, who is so intent on trying to find some sort of hypocrisy in my personality or try and damage my business. The exact thing that Maddox is suing people for, by the way, is the thing that you have done to several people, including me. Please stop, because it's pointless. You have plenty of more people with higher followers to go bother. Go do that. That's fine. But even you, I hope you got to spend Easter with some good people, because aside from your internet personality, you are a person, and you deserve some happiness in your life too. So thank you all. Y'all have a good night.